You got comments coming in.
Okay.
So we got 6 people.
Are we talking to them right now?
Yeah, they can hear us.
Hi everyone. I'm Christopher's mom. My name is Diana. Some of you may know what's going on with Christopher, and he's going to be absent from his live stream for a little while. So I am just going to fill in and just keep his site going. Feel free to ask me any questions about my son, about me, about how I feel about things. I just want to get to know you guys and hopefully see what you guys think of my son. I'm very proud of him and the things that he is doing. His activism is wonderful. So I'm looking forward to connecting with all of you in the next couple weeks. So yeah, and here's Christopher to tell you kind of what's going on with him. Yeah. Okay.
All rise. Court is now in session.
Please be seated. 22 PO 7015, United States of America versus Christopher Cordova. Please make your appearances.
Good afternoon, Your Honor. Craig Chancellor on behalf of the United States.
Thank you.
Good afternoon, Your Honor. Milo Schwab on behalf of Defendant Christopher Cordova, who appears in person beside me.
Thank you both. All right, we're here for sentencing. You have the floor.
You need to take that outside, sir. Take that outside.
What are you doing? You can't block my camera, man.
Yes, I can.
You guys can't come in here. Hey, don't touch me, bud.
No, yes. I will advise you. You're allowed to outside.
Hey,
so.
Back up. Don't touch me, bud. What are you doing? Hey!
Oh!
Hey, don't touch me, bud.
No. Hey, don't touch me! Get out! Don't touch me! What are you doing?
Don't touch me! Don't touch me! Don't touch me!
I am. Sir, you're pushing me. Stop touching me.
Don't touch her. What are you doing?
Here I go, guys.
Wait.
They're going to arrest you, man. Ready?
There you go. There you go.
You're now under arrest. What are you arrested for? You're now under arrest. They're arresting.
I'm under arrest, guys.
Come back here.
I'm under arrest.
Come back here. Keep rolling. Keep rolling. Come back on.
I'm under arrest, guys.
That's very sweet. I like that. Metro Mama. Yeah, that's me.
Hey guys, this is DMA. Most of you know me, but for those who don't, I'm a civil liberties activist whose advocacies entail many aspects of civil rights, including cop watching, addressing public officials through making public comment at city council meetings, interviewing of police officers, attorneys, public officials, other activists, and victims of civil rights violations, as well as helping others by coaching them on how to successfully carry out their own activism and give my opinion on how to manage the aftermath of unforeseen hardship due to simply trying to be a free American. But the portion of my activism that I'm most well known for is called First Amendment auditing, where I take pictures and video of anything I can see from a public space, such as a traditional public forum like a public sidewalk, a limited public forum such as a public library, and even a non-public forum such as the lobby of a Social Security office. If you're new here, you might be thinking, but DMA, why would you record at such a place where valuable private information is being discussed? Well, my intention is not to leak private information, and I never would if it got picked up by my camera, but it's to expose the fact that government is the one who is being careless with your private information by forcing you to conduct business in a public lobby. Regardless of my camera, people could still see and hear this private info. And despite the fact that First Amendment audits are becoming increasingly popular and continue to expose government's ill-planned processes, they'd rather just convince you that I'm the bad guy, that I'm breaching security.
The nature of the defendant's conduct in this case is that he repeatedly put his own interests over the public interest. He didn't care about concerns raised by Social Security customers on August 2nd. His videos show belligerence and, frankly, animus toward law enforcement officers. He gets officers' names, badge numbers. He gets officers' names, badge numbers, and phone numbers so he can encourage his audience to call and harass the officers and their supervisors and to file reports with their employers.
Or better yet, that I'm just trying to provoke a reaction for YouTube clout and money.
His actions, as seen in the trial, were calculated to provoke. His purpose was to get viewers and attention and post it to his YouTube channel so that he can get additional donations from the same event. It was a financially motivated crime. Mr. Cordova sees YouTube profits and YouTube views as more important than concerns of others. He had received a substantial amount of money from his YouTube channel. He and others commit crimes like the ones at the Social Security office for profit. He continued to post these videos, in short, because it's profitable to do so. The court sentence should send a message to those who are contemplating similar action, putting YouTube fame above the public interest.
Like U.S. Attorney Craig Fansler said, instead of making the necessary corrections to their ineffective operation, they'd rather display narcissistic behavior by shifting the blame on me and locking me in a cage.
The videos on his website show that his brand has become to get arrested on YouTube to gain profits, and the sentence today should take those profits away. And for all those reasons, the government believes that a fine of $5,000 and a sentence of 20 days of imprisonment is sufficient but not more than necessary under all the sentencing factors.
But DMA, you said it's a non-public forum, which means the federal government can create rules regulating conduct on federal property based on 41 CFR 102-74.420. Oh, shoot. Got me there. My bad. Psych. Just because it's a non-public forum doesn't mean you have no First Amendment rights at all. So if there's no official rule stating photography is prohibited in the lobby, guess what? I can take pictures in the lobby. But wait a minute, DMA. They claim there is a rule, and Judge Hegarty found you guilty of violating that rule and disobeying lawful signage stating the rule. Yeah, and government never gets anything wrong. Just like 40% of police officer families don't experience domestic violence, and all public officials not only understand their oath of office, they honor it too. Even though Judge Hegarty believes the rule exists, and he believes the rule exists clearly not by doing any research, but by blindly believing what he was told, in his verdict, he acknowledged that I can take pictures in the lobby. But he's agreeing with the prosecution that the space I was in was a space occupied by the tenant, because it's a space where people are conducting business. But our argument is that it's a lobby and government is choosing to conduct business in the lobby. I mean, look at this place. There's pamphlets to grab, posters on the wall, chairs to sit in. I think every single person who has ever been to this office would agree that this is a waiting area. And guess what a synonym is for a waiting area? That's right, lobby. And it doesn't stop there. Let's read what Judge Hegarty wrote in his verdict. On the other hand, through that interior second set of doors, the SSA conducted its primary business of assisting the public. During Mr. Cordova's filming, members of the public, parentheses, including children, in which I don't understand why he had to throw that in there, and to be frank, my patience is wearing thin with people acting as though I'm some kind of creep for inadvertently recording children. I mean, if I record in a location that's plentiful with children, such as a playground, and my intention is to specifically record children, not illegal, but yeah, that's kind of creepy. But I've never done that. Okay, here's the important part. Members of the public, including children, were indeed conducting business there. People were in chairs waiting for their turn. So Judge Hegarty is implying that this space is both an area where people conduct business and a lobby. Except, of course, he doesn't use the word lobby. He says people were in chairs waiting for their turn. You see how ridiculous this is? You see how hard government is grasping at straws to shut us down? This is absurd. But wait, there's more. Arresting Officer Commander Douglas P. Wiles referred to that space as the main waiting area. Officer Oscar Ramos referred to it as either a lobby or waiting area 13 times, who, by the way, is the man who pushed Sweet Tea out of his way like she's a rag doll, as though he's the emperor of the Social Security office and can do whatever he wants. Social Security Office Manager Randy LeCavalier twice referred to it as a reception area. Synonyms for reception area include lobby and waiting area. And security guard Marcos Chavez, who went hands-on with me within 30 seconds of entering the foyer, and as you can see, I reciprocated force to remove his hand from touching me, and they didn't charge me with anything for making physical contact with Chavez, because they knew he initiated the contact. but I can almost guarantee that if I had initiated the contact, I would have been leaving in handcuffs with additional charges. When I informed Commander Wiles about Chavez going hands-on with me, he said,
Well, I just watched the video and there wasn't an assault.
There wasn't an assault?
Define that assault to me.
No. Hey, don't touch me! No. Hey, don't touch me! Don't touch me! Don't touch it out! Don't touch me!
Well, I watched the video and that's not the impression that I got at all. It looked to me like he was just, kind of pointing towards the door. It wasn't violent at all, so.
Back up! Don't touch me, bud! What are you doing? Hey! Oh!
Anyway.
But I digress. In-security guard Marcos Chavez referred to it as either a lobby or waiting area 4 times. And last but surely not least, in-security guard David Williams, who repeatedly went hands-on with myself and Sweet Tea, and subsequently put this bruise on her arm. Of course, no charges were filed on Williams, and he even had the audacity to sit in the pews during my trial. He referred to the space as a waiting room 6 times. So including 2 DHS officers, 1 Social Security office manager, 2 in-security guards, and 1 Chief Magistrate Judge of the United States District Court for the District of Colorado referred to the space in question as a lobby 27 times. But Judge Hegarty's pride and ego was on top of the Rock of Gibraltar and concluded that the government is right and DMA is wrong. And the space where I recorded DHS officers in the course of their duties for a total of 16 seconds, and where he wrote, quote, "People were in chairs waiting for their turn. Members of the public, including children, were indeed conducting business there."
He should have been raised better and known to keep his mouth shut. Horrible mom.
See, this is what we're talking about. The trolls.
You know what? I do want to respond to that. You don't know me. You don't know what I've been through. You don't know what Christopher's been through. So, to judge somebody is really unfair. I could probably say some things about you if I just met you, and that's just not cool because you don't know me at all. You don't know anything about me. You don't know anything about my son. So shame on you.
He also gave links to his merchandise using the same phrases he'd used in those videos, again, to drive profits over the people in the agencies and the law enforcement personnel that he had antagonized over a period of time.
Yes, he has catchphrases from his protected activity too. Things that he says in video after video after video. Do better. Because sometimes, you know what? Police officers do need to do better.
And remember, they banged on the door. My daughter was like 16 years old. She was scared to death. Called me up, told me what was going on. I went to the house, called the head of that police department, and he came down that evening to talk to me because I was very upset with the fact that how could you do this? Who do these people think they are to come into the door, banging on this, scaring a 16-year-old girl who had nothing to do with it. And
they said they were going to arrest her or something too.
Yeah, they were threatening her and everything else.
And to try to impose a fine on the basis that he sells merchandise, that is stretching the bounds of saying that he is getting ill-gotten profits.
My goal as an activist is no longer to affect change. After almost 4 years of doing this, I'm way past the point of believing there could actually be change. I've shifted the focus of my mission to simply exposing the truth. And the truth is, government gets it wrong. A lot. And they got this one wrong. A lot. You see, I'm only one of many who got convicted of these CFRs for recording in the Social Security office. Let's go back to this quote-unquote rule that prohibits recording. You see, I have this friend, Bay Area Transparency. You may have heard of him. He has a small YouTube channel doing employee conduct checks where he got arrested for doing the same. After my arrest, Sweet Tea and I did a panel later that night to recap the event, and Bay Area Transparency was in the chat. After that is when him and I started talking, and so we started communicating about our cases, and he sent me this response letter to his FOIA request on the rule that prohibits photography per 41 CFR 102-74.420. And guess what it said? CISA has conducted a search of the files within the CISA Infrastructure Security Division for records responsive to your request. Unfortunately, we were unable to locate or identify any responsive records. So there you have it, guys. Government got it wrong. There is no rule and there is no signs. All those signs was somebody in an office who printed up a sign on their computer, laminated it, and threw it up on the window, and then said it's an official rule, and it's not. And my attorney brought up the fact that there was no rule to make these signs legitimate during my trial.
I would say the evidence does not support a finding on a reasonable doubt that these are official signs. The United States could have brought someone in to speak to how these signs came to be posted. They didn't. That was their choice. But they have an obligation to prove each element beyond a reasonable doubt, and one of those elements is that these signs were indeed official. And I have seen no evidence. Certainly Mr. Wiles does not have that personal knowledge.
Commander Wiles did talk about them coming from the Central Social Security Administration. And the other thing, I don't think Your Honor even needs that testimony. You have the photos that show the official seal on the bottom, the GSA seal and the SSA seal. It says federal law and SSS policy does this.
And you know what Judge Hegarty said?
Those numbers, you should Google them.
Okay.
I haven't found anything.
The ICN?
Yeah.
Well, not everything's on the internet. Okay.
You can't believe everything you hear on Google.
I would hope that the government regulations are, though.
I'm not even sure what ICN stands for, International something number, but whatever. Okay, so
this is a big in-your-face to the trolls and to the people in the 1A community who turned their back on me over the case law United States versus Cordova. If you're part of this community, you have to think critically. You can't just blindly believe something's true because the government said so. That's what cops do. You gotta do better than that. Let's say, for the sake of argument, that I am guilty. Let's say this goes all the way to the United States Supreme Court and it's a 9-0 unanimous decision against me that I supposedly do not have the right to record in that space. Even then, I would still believe that I should have that right. And based on the massive attention this audit received, I know a lot of you believe the same thing. So here's my question. If the government makes a tyrannical, unconstitutional ruling, why would you blame me for making bad case law? Why aren't you blaming the people who violated their oath in the first place? And here's the funny part. I even heard another activist say publicly that I made bad case law. But when I spoke to him privately, he admitted he thinks the judge got it wrong. So why would you tell your audience I'm the problem if you don't actually believe that yourself? Most of you understand it's not my fault, but for the ones pointing fingers at me, you and I are not the same. I could never blame a fellow activist who put his freedom on the line, got arrested, got convicted, and is now dealing with those consequences, and then somehow pretend he's the enemy instead of the government that abused its power. If you're blaming the activists instead of the system, you've already taken the government's side.
If you're happy because somebody's getting put in jail, that's just wrong. That's just wrong. That shows what kind of person you are. You shouldn't even be on here. If you don't like something, then don't be part of it. Just don't be part of it. You know, you don't, like I say to my son on both my kids all the time, silence speaks volumes. So if you don't want to be part of this, then don't be a negative part, don't be a part at all.
I believe Bay Area is the first one to audit the Social Security office. And before I saw his video, I had been wanting to audit the Social Security office in Littleton, Colorado for quite some time. Every time I drove by there, I was like, oh, that would be a good place to do an audit. And my intuition was screaming at me that it was going to be a fiasco, but I never got around to it. So when I saw his video, I took it as a sign that it was time. On the day of the audit, I was with my #1 sweet tea. As we were scoping out the parking lot, we were immediately met outside the doors by security guard Chavez, and it was at this point that I knew my intuition was right, and I told Sweet Tea to go live. As soon as we entered the foyer, we were met by in-security guard Chavez, who takes his job way too seriously and went hands-on with me immediately. When Sweet Tea and I first walked inside, I was under the belief that it was just us two, but after about 10 minutes, it quickly jumped to 300 of us. 2 in the foyer and 298 in the chat. After 20 minutes, it was 700. 10 minutes later, it was 1,100. Then 1,300, 1,400, 1,500. Every time I glanced at the chat, there were 100 more people in there. As the person conducting the audit, I'm only one part of the equation. Without all of you, none of this is possible. It was hair-raising to see the chat grow exponentially, as at this point in my career, I had about 30,000 subscribers, and the most I ever had in a live stream was about 300. Not only was the chat explosive, but I had some highly influential people in the chat, such as Lackluster, Accountability for All, Long Island Audit, Here's the Deal, and more. During the climax of my live stream, the chat reached 3,500. As a newbie, this was electrifying and gave me the confidence to say this.
So the only way that we're leaving by force is in handcuffs.
Chili happened to be in town at the time, and when he caught wind of what was transpiring, he came to back us up. I've had dozens of people tell me in the comment section and in person that Chili convinced me to go in and get arrested. And I know thousands of you watching this video right now also believe that. But when I said,
the only way that we're leaving by force is in handcuffs.
Was Chili there? He didn't show up for like an hour after I said that. And if you watched the stream, you heard me say that before Chili ever arrived. Chili happened to be in town, he saw the stream, and he came to back us up. That's it. Support doesn't equal influence. So if you agree with what I did or you don't, that's fine, but let's at least be accurate about how it went down. I'm not claiming to be the biggest alpha dog in the pack, but I'm also not a follower of any man. I make my own decisions, I own them, and I take responsibility for them. United we stand, divided, I still stand.
You learn your rights, but it's like you learn the Bill of Rights, the Constitution, but it's not a deep education. It's just a skim over.
You had civics when you went to high school, right?
Yeah.
Yes.
Yeah.
There's no civics anymore. We didn't have civics when I went to high school, and they don't have them now. Maria didn't have it.
Really?
Yeah.
You guys didn't learn any of that stuff?
They stopped teaching that in public schools because they think about it. It's a government-ran school. Why would the government want you to know your rights so you can know how to revolt against your own government?
In the beginning of this voiceover, I said that sometimes I audit non-public forums. Even if this is a non-public forum and there is a rule prohibiting photography in the lobby, which there isn't, it doesn't matter. Not to me. Non-public forum, limited public forum, designated public forum, traditional public forum. It's all a bunch of nonsense created to oppress you, violate your natural rights, and make you a slave. If it's open to the public and the public can be there, we should have the right to take pictures in there. I don't always record in places where there's established case law that protects your right to do it. Sometimes I record in places where they say I don't have a right to do it, because that's how we affect change. Some people in this community have criticized me because they say my channel is based on following the law, so I should follow the law. I don't know where these people get the idea that my channel is based on following the law. My channel is based on civil disobedience. You'll hear me say in this video that at one time, Rosa Parks was considered a troublemaker, and now she's regarded a hero. This country was founded on questioning authority. It's the most American thing you can do. So that's the Cliff's Notes version of this audit. I end up getting a 15-day jail sentence, but only had to serve 16 days of it because they left me in there for an extra day. This entire ordeal was mishandled, but all I can do is either lay down or continue to fight. So I'll just keep going and do the best I can to turn my pain into power. So this video is going to be something different for you guys, with audio transcripts from the court proceedings from my trial and sentencing, as well as security camera footage of me in jail, along with phone calls I made and video and audio of the one visit I had. There's no audio of the security cameras, so I'll be adding voiceovers to explain what's going on and expose the Jefferson County Jail and all of the corruption that's going on in there. So this is going to be something new and exciting for you guys. I don't think anyone's ever done anything like this before, so I really think you'll enjoy it. I spent an incredible amount of time putting this one together for you guys, and I'm really proud of this piece and think it's some of my best work, so I'm really excited for you to see it. Let me know what you think in the comments section, guys. Enjoy the video.
On the record in the trial of the United States of America versus Christopher, is it Cordova or Cordova?
Cordova.
Cordova. Christopher J. Cordova. 22 PO 07015. Please make your appearances.
Good morning, Your Honor. Craig Fansler and Tom Minzer on behalf of the United States.
Thank you. Good morning to you.
Good morning, Your Honor. Milo Schwab on behalf of defendant Christopher Cordova, who appears here.
Okay. Do we want to have brief close opening statements?
On Tuesday, August 2nd, 2022, just before noon, this defendant, Christopher Cordova, went to the Social Security office in Littleton, Colorado to commit a crime by live streaming video because he wanted to create a court case. He planned, before he got there, to ignore every sign and everyone who told him not to film, and he did exactly that. He ignored the agency's customers that day, who didn't want him filming their private business inside a Social Security office. Of all the places he could have chosen to engage in criminal disobedience, he chose a Social Security office. He picked an agency whose business is private, confidential information. On August 2nd, Mr. Cordova saw 4 signs prohibiting the live streaming. He ignored those signs, as he planned to do all along. He was told more than 8 times by 4 federal security officers that he could not film inside. Mr. Cordova ignored these directives, as he planned to do all along. He was also given a copy twice of the General Services Administration regulation prohibiting photography. Mr. Cordova ignored this regulation, as he planned to do all along. Instead, he set up his camera so that it faced a sign prohibiting photography, and he did that for 3 hours and 13 minutes. It's clear that he did not like the signs.
That's what we're talking about? There is this right here, okay?
Let me see. Let me get a shot of that.
Photographic devices may not be used to take photographs or make video recording.
That's not a CFR though. Yes, that's just a piece of paper. Anyone can write. You could write no red shirts.
And you're still doing it.
That's not a law, sir. That's just a piece of paper.
Posted by the Social Security Administration.
That's not a law. It's not a law, sir. Yes, it does have to be a law. We know what we're doing, man. It has to be a law. It's just a piece of paper. It's not a CFR. Trust me, I've done my research before we came in here. We know what we're doing.
A piece of paper, so he ignored it, as he planned to do all along. Finally, between 3 and 4 p.m., after at least 3 hours and 13 minutes filming from outside the office, he committed the crime he went there to commit. He walked inside while continuing to live stream, as he had planned to do all along.
Here I go, guys.
Great.
They're gonna arrest you, man. Ready?
There you go, Dan.
You're now under arrest.
What are you arresting
You're
for?
now under arrest.
They're arresting
I'm under arrest, guys.
Come back here.
I'm under arrest.
Come back
Keep
here.
rolling. Keep rolling
Come
your
back
film.
here.
Keep rolling your film. They're arresting.
Come back here.
I'm under arrest, guys.
Mr. Cordova got the court case he wanted. Mr. Cordova intended to commit a crime. He set out to commit one that day, and he did, because he viewed the First Amendment as a license to ignore every sign and every officer. It is not that type of license. This is a simple case. Proof of each element is on the video that Your Honor will see. The defendant made one long confession, and he posted it to YouTube. That confession proves his guilt beyond a reasonable doubt on both counts. Thank you. Your Honor, the government calls Commander Douglas Wiles. Thank you. Good morning.
Good morning.
I want to turn your attention to August 2nd, 2022. Where were you at in the morning of that day?
I was at the range, firing range.
And did something happen to cause you to leave the range that day?
Yes.
What happened?
I received a phone call from one of my inspectors advising that they had a situation at the Social Security office, 8000 South Park, where some First Amendment auditors were attempting to film inside the facility, and they had been asked to leave and were refusing, and according to my inspector, the situation was escalating.
When you arrived, did you encounter an individual you later found out to be named Christopher Cordova?
I did.
When you arrived, did you see individuals recording video?
I saw individuals with cameras. Yeah, I'm not sure if they were recording at the time or not, but
how many individuals?
2 for sure. Mr. Cordova, and then another identified, only known to me as Sweet Tea.
Did you later see 2 videos from that day posted to YouTube?
I did.
That were posted to YouTube? The government would offer into evidence Government Exhibit 1 and Government Exhibit 4 at this time, which are those 2 videos that the witnesses just talked about.
A response?
As discussed earlier, for Exhibit 1, we have stipulated to it with the exception of those hearsay objections. He can testify to those moments that he visually watched, but to say I watched a video and therefore I know of its contents, I think that's hearsay. He doesn't have personal knowledge.
That's undoubtedly true. So what is relevant to this witness's testimony would be only those matters that he saw.
And did we? Did we admit the? I guess I want to formally move for admission of Government Exhibit 4.
I think you already did.
Okay. Yep. So if we can go ahead and play that clip.
Another officer here. Also, thank you for the PayPal. I got a PayPal I saw. Hold on. We could be doing better, to be honest with you. Well, I mean, we came into a public building that we pay for to do a story here. And Title U.S. Code 102-74.420 allows us, for news purposes, to come into this public facility and record in the foyers and the hallways. We wanted to get some pictures and some pamphlets and stuff like that for our story. We would probably have been gone at least a half hour ago, to be honest with you. We got assaulted by both of these security guards, but went hands-on me. So I want to.
Were you guys inside the?
We're in this foyer. We've been in the foyer.
Okay. All right, well, we'll talk about that in a minute. Okay, let me see what these guys say.
Can I get your name and badge number?
Yeah, I'll talk to you in a minute.
Okay. All right, guys.
Commander Wiles, what did you do after that initial interaction?
I went inside and spoke with the PSOs, my inspectors that were on scene. Just got everybody's perspective on what had taken place prior to my arrival.
And were there other Federal Protective Service officers already on the scene when you arrived?
There were two.
Who were those individuals?
Inspector Doug Pritchard and Inspector Oscar Ramos.
Commander Wiles, I'm going to play one more clip and then ask you some questions about it.
Just like that, we'll do a request. So if they do that, I'm pretty sure it's their policy that they're not supposed to take pictures of us unless it's for... So hold on, I got to go back to Long Island Audit's super chat.
Just to give the two of us. This one right here.
Fellow Patriots, remember my trial in Berwyn, Illinois is August 10th, next Wednesday. We the people will win. Don't forget his trial, guys.
Hello, everybody.
Okay, so we got this DHS officer, I'm assuming is some type of, what's it called, a supervisor. But they're reading the policy here, guys. You see the policy? It says federal law and SSA prohibits taking pictures, but there's no CFR posted on that. It's just a piece of paper. I mean, I could write no red shirts allowed, and I could write anything on there on a piece of paper. There's no CFR to back that up. If there's no law to back it up, we can be here. You have to have it officially posted with a CFR.
Commander Wiles, what are you doing in that video?
Reading the signage that's posted on the windows of the foyer there.
Was that sign in the video that we just watched?
It was.
Can you just read what it says and what you saw that day?
Sure. It says Social Security Administration warning. Photography and videography prohibited. Federal law and SSA policy prohibits taking pictures or video inside SSA offices without the express written consent of an authorized official of the agency. These rules apply to all devices with camera and video capability.
Who developed the signs that were posted at the Social Security office that day?
I'm not sure who develops them, but I know where they get them. They have their central office. I'm not sure the terminology they use, but their headquarters division has an internet website where they post the signage, or they make it available to all the branch offices to go retrieve that signage and post it. And it's required posting at all facilities.
So your understanding is it's an official sign from the headquarters?
Absolutely, yes.
Objection, Your Honor. That was leading. It's an official sign.
Hey guys, here we go. Camera on. Camera on.
Hello, guys. Hi. All right, where were we?
Yeah, so where we were was that I was reciting you the law. So it's Title U.S. Code, U.S. Title Code 102-74.420, which states that we have a lawful right to, it's a 2018 memo, Department of Homeland Security, that states that for news purposes, we can come into the public accessible areas and record. So that's what we came here to do. We came here to get some pamphlets, some information. They have public information in here. We're not here to get people's social security numbers, but we got assaulted by both of these guys. So we need to
watch the video.
Yeah.
There wasn't an assault.
There wasn't an assault?
Find that assault too.
Well, it's not assault in Colorado. It would be, in most states, it would be battery, but there is no battery in Colorado, so it would be like either harassment or menacing. To put hands on another free American, an individual, and shove them into the corner over here.
Well, I watched the video, and that's not the impression that I got at all. But what I will do is make sure that your contention gets into the report that we're going to type up for this.
Okay.
And then we'll also attach the video, and we can, if it comes to that, we can see who decides what. But it looked to me like he was just, kind of pointing towards the door. It wasn't violent at all, So anyway, I'm going to give you a copy of the CFR, the Code of Federal Regulations, that talks about where you can film and where you can't, and when you need the tenant's permission and when you don't. I'm going to give you guys a copy of that, so you have it for your reference today and moving forward. Also, the secure space in this building starts at that door, okay? It's not this door. This is just kind of I guess an air conditioning buffer, if you will, like a climate control buffer. The actual controlled space for this facility starts at that door. That's the door that locks it up, okay? So this sign applies to this area. I have spoken with the facility manager, and he is perfectly okay with you guys could be compromised, for people's personal business, or...
Now it's hearsay if he's saying what somebody else said.
Right. So do you know why we have a rule against hearsay?
It's for the purposes of trustworthiness.
Correct.
Yeah.
And if we have the actual words, then this would clearly be an 807 residual
Sure,
exception.
and I'm not saying that his words are hearsay. I'm saying him repeating someone else's statements that could have very well been brought in to testify today. That statement.
Whose words were he repeating?
He was repeating somebody that worked in the Social Security Administration office.
I see. Okay. So it's hearsay within hearsay is what you're saying.
Yes, Your Honor.
Okay. What's your response to that objection?
A few things, Your Honor. The defendant all along is asking both for FPS's interpretation of the rule and why Social Security has that rule. He's coming out and explaining it to him. That gives the defendant knowledge and notice, which is something he expressly asked for. He then, it has an effect on him because then he decides whether he's going to follow that.
Right, but don't you think the signs provide sufficient notice without the oral commands of anybody?
I mean, it didn't seem to.
That's all, folks.
I mean, it didn't seem to. The fact is that the defendant throughout is making statements that he wants more and more and more information, and so I don't really want to give him the profit of keeping out admissible statements that he keeps asking for.
I'll grant the objection because that is hearsay, and I will compartmentalize and strike that. Okay?
I appreciate your
right. Thank you.
PII information that could be compromised by you guys being in the lobby, and we're okay with that. If you guys want to stay out here, we're not going to give you a hard time at all. You can stay here till they close. Don't care. Okay? The problem we'll have is if you try to come inside where you can hear conversations taking place and potentially see information. Okay? So here, we're not going to bother you a bit.
Can I get your name, Inspector?
Yeah, my name is Doug Wiles. I'm the commander for this area, and my badge number is 889.
You have a business card?
Sadly, I don't, but I'll give you that information. I usually do have a business card, but I just put it in a backpack on the plane I got off of it. Forgot to take them out and put them in my pocket. So
I got a question for you.
Sure. Did you guys want this?
Did you swear an oath of the Constitution when you took your job as inspector at the DHS?
Of course I did.
So are you going to honor your oath then? Because
about
preventing us from coming in here is not honoring your oath.
No, you can come in here if you have business to conduct.
I do have business.
But you cannot come in here and record.
Yes, I
That's
can.
specific with
Yes,
all
I can come in here and
SSAs
record.
across the country.
I can come in here and record. According to the 2018 memo, sir, I just gave you the law.
According to that sign right here in the law that I'm trying to give you, but you're refusing to take.
This is not a law. That is a sign that has no law.
That sign is referencing this document. Now, if you choose not to take it, that's fine with me, but
I'll take it.
There you go. It is prohibited inside this facility. We're not going to allow that. We will allow you to be out here. I don't know what more of a, how much nicer I can be about it. Do you? And let's be clear, we're not here to interview me about my training and history. That's not why we're here. I'm here to try to find some amicable solution to this situation. I think I've been very generous and forthcoming with you about what we will accept and what we won't accept. And so hopefully you're agreeable to that. We don't have any further issue.
Yeah, you've been super cordial and respectful as you violated our rights, man. So yeah,
How did I violate your rights?
If that's what you want. Well, you're saying that you're going to arrest us if we go into this building, sir. That's not lawful.
Well, I haven't said that, have
Well,
I?
let me ask you then. Are you going to arrest us if we go in there?
Well, I don't know about that. There's definitely, if you violate that law and the law I just gave you, there's going to be some sort of consequence for that. I would probably like to get the advice of the U.S. Attorney's Office and see, we could arrest you for that. Sometimes, you know, they think maybe it's a better idea to write a ticket. I'm fine with that. In either case, if we had to do that, what we would do is take all your equipment as evidence, and I don't want to have to do that. So hopefully it doesn't come to that.
We wanted to get some of these brochures that were in here. I needed to get some for the people that I work with, and I'm being refused. I just wanted to show documenting that I'm getting those brochures.
Oh, I want you to have those brochures. However, you cannot take that camera in and record inside this facility. That won't happen.
So I can take my phone in though, right? Because everybody else has their phone.
As long as you're not recording.
Yeah, that's not true, sir. That's not true.
That is true, and this isn't the time and place to argue it. I'm telling you right now that I'm not going to allow you to film beyond this door. I'm already allowing you to film beyond that door.
You're not allowing me to do anything.
Commander Wiles, can you just, what did you give him in that video?
A copy of 41 CFR 102-74 420.
Commander Wiles, we've watched a few clips now. Why didn't you just give Mr. Cordova a ticket when you arrived?
It's really not the way I like to do business. I like to give people the opportunity to do the right thing, educate them, explain the situation, give them the opportunity to follow the rules and the laws.
And why do you do that?
I think it's good police work. I just think a lot of times people are, I guess, misled or have a misconception of what's okay and what's not. So I believe in education versus incarceration, if at all possible.
During your observations that day, how did Social Security Administration customers react to Mr. Cordova filming?
There are a variety of reactions. Some people were visibly uncomfortable with what was going on. There was a pretty large police presence at times. Some people were concerned. It seemed reluctant to come inside because of the heavy police presence. Other people were, visibly shielding their faces from the cameras, maybe even exchanging comments with the videographers as they were coming or going from the building. At one point, there was actually a confrontation outside between somebody who was filming and one of the customers who was exiting. That caused several people to go outside, and including myself, to try to, for different reasons. I'll speak to why I went outside to de-escalate the situation, because it was seeming to get pretty heated in a verbal exchange.
And I just want to play one clip here, which is...
I don't want to be filmed. Why don't you ask?
Well, get the hell out.
Stop.
Shit, nobody worried about you.
I wasn't even going to record her, but she has to be rude. HBO Matt.
Was that one of the interactions you were discussing?
Yes.
I want to direct your attention now to your interactions with Mr. Cordova and others live streaming that day. This is just to front what's going to happen here. This is a clip of another officer when Commander Wiles is present giving a command, and just to know that the defendant had notice from multiple officers, the non-hearsay purpose of notice from multiple individuals and not just this officer. So that's what I want to play, just a 4-second clip showing that notice from another officer.
Publicly funded building. There are signs posted, no photography.
Who's in that video?
Inspector Ramos.
And were you also present at that time?
I don't know.
You can't see it from that clip. Okay. I'm going to show you a couple clips. I'm going to show two of them and then ask you questions about them.
Jeez, man, this guy just can't give it up. Your pride and ego is so big.
Better shut your mouth.
Oh, you are? Thank you.
Gosh, man, the guy's ego is like so huge. He just has to give me a directive. I'm gonna stand right here, man. And you're not gonna do anything about it, bud. I promise you that.
Mr. Cordova, in that video, well, let me back. You know whose voice that is in that video?
It sounds like Mr. Cordova.
And he called it a directive in that video. Do you agree?
Yes.
Yeah, just that. And the last clip I want to play is Government Exhibit 1.
You heard another one? I was calling you. Yeah, I mean, oh no, the door's open! Oh no, look at him, his little dog!
So, you guys, this building closes at 4, just so you know.
Right, but here's the thing, is you guys are going to face a lawsuit.
Okay.
Because what he just said and what you have done. You have messed up today, my friend.
Okay.
You have his information? You have all their
So the
information?
building closes at 4.
8, 8, 9.
What time is it now?
You know, I don't know.
I mean, are you sure?
building closes at
Hey, do you
4.
need to grab the door? Are you scared? Do you need to grab the door? I don't want
And
to
you guys have all been advised you can't film past
Grab
this
the door.
threshold.
So are you just staying here now for personal security?
No,
to
I'm
keep us
walking
from coming?
away.
Hey,
You're walking away? Okay, because when you leave, we're going to go in here.
You mad as shit. You mad as shit, boy. Yeah, walk your shame. Walk your bitch ass on to the back.
Okay, should I go in?
You think so?
Here I go, guys.
Great.
They're going to arrest you, man. You ready?
There you go, Dan.
You're now under arrest.
What are you arrested
You're now
for?
under arrest.
They're arresting
I'm under arrest, guys.
Come back here.
I'm under arrest.
Come back
Keep
here.
rolling, keep rolling
Come
your
back
film. Keep rolling your film. They're arresting.
Come back here.
I'm under arrest, guys.
I don't know how to shut this off.
Cuff him up.
Commander Wiles, what did you do after Mr. Cordova filmed inside the Social Security office?
Took him into custody.
Who was the arresting officer?
Me.
Did you seize any physical evidence from him when you arrested him?
I did.
What did you take?
His cell phone that he was filming with.
No further questions, Your Honor.
Cross.
Good morning, Mr. Wiles.
Good morning.
Did you write a report after this incident?
I did.
Do you recall all the statements in it?
For the most part, yeah.
Okay.
Couldn't recite it to you verbatim, but I know the general context of the report, yes.
Okay. Do you recall describing the location where they were filming for those 3 hours as the foyer?
I don't recall, but that's likely.
Okay. If I were to hand you your report, do you think that would refresh your recollection?
Sure.
Page 1, and just to direct your attention, it's going to be the 4th paragraph, the 4th line in the middle. Starts with above, I explained to.
Okay.
Does that refresh your recollection?
Yes.
Okay. And in your statement, did you refer to the area that they were filming in as the foyer?
Yes.
Okay. Now, earlier you testified that the sign was a security sign, correct?
Yes.
Okay. Where do you know that from?
I've actually seen the categories and what signs fall under which category.
Can you list out all of those categories for me?
Well, I previously stated I don't know them all, but I can give you the ones that I do recall. There was a inquiry as to where these signs officially come from. That email specifically directed us to the internet website where the signs are available for retrieval. And these particular videography signs were in the security signage folder on that internet website. So I didn't actually visit that myself, but that was provided as an attachment directly from the website in the email.
So you don't have personal knowledge to its location as a security regulation?
I've not been there to retrieve a sign, correct.
Okay. And you don't know who described it as a security regulation?
I couldn't tell you the name, but I will also tell you that one of my inspectors was tasked with contacting the facility director at this particular facility, asking him where those signs came from. And that's the information that he provided as well, verbally, which was corroborated by the email.
This is getting into hearsay.
Sure, but is it even relevant? I mean, the count one says official sign of a prohibitory, regulatory, and directory nature. It doesn't say anything about security, so it's not relevant.
Sure, but as to the second, one of the two counts says a security regulation.
So that'll be a matter of law.
Sure, and I want to get a little more into that, okay? You're familiar with this Social Security office? You've been there?
Yes.
Was there a metal detector?
No.
Okay. Were there any other security mechanisms in that office?
Define a security mechanism.
A mechanism for the security of the individuals entering in or those employees that are present?
Halo camera.
There are video cameras, yes.
Doors. Some doors you can lock.
Okay.
Security officers, video cameras.
Okay. And do you recall if you described in your report the purpose of these signs?
Did I describe the purpose of those signs? I don't know.
So let's take a step back. You said in the moment you received information as to the purpose of these signs, correct? When you were there, you called around and you were told that these were security signs, right?
No, not at the time.
No? Okay. Did you call around to get information as to the purpose of these signs?
No, I didn't need to do that. The purpose of the signs is self-evident when you read them.
Okay. And what is the purpose of those signs as you described that day?
To prohibit the filming or photography or videography in the facility.
Okay, let me put it a different way. Did you say that you explained to Mr. Cordova that due to the sensitive nature of the conversations that take place in the facility and the prevalence of personally identifiable information within the facility, that's the reason that filming is being prohibited?
Yes.
Okay, so it was about the personal information.
Correct.
Okay. You don't write anywhere in here that it's to protect security concerns. And I'm talking about this report that you generated, I assume, that same day?
I don't think I used the word security in this report at all.
Okay. Do you know who placed that particular sign, the individual that placed the sign or any of these signs in these windows?
Of course not, no.
Okay. Have you seen these exact signs elsewhere? And I mean in like these are official signs. Have you seen that sign?
Yes.
Okay. And who adopted those signs? Based on your personal knowledge, what individual signed off this sign is, this sign has been adopted?
Well, I don't know the answer to that, but what I do know is, as I stated previously, it's required signage at all Social Security offices, and all the ones that I've been to have this signage.
Okay, but you can't tell me what action created the adoption of this sign?
No.
Okay.
A directive from their headquarters is what I assume, but I don't know.
But you don't know. Okay, no further questions, Your Honor.
Thank you. Any redirect?
No, Your Honor.
May I step down, sir?
Thank you.
The government rests.
All rise, court is in session.
For the defense.
Your Honor, before I make my opening statement, I'd like to move under Rule 29 for judgment of acquittal.
Okay. Did you want to make argument or not?
Yes, Your Honor.
Go ahead.
As to count one, I have several different arguments. The first is that this is a lesser included of the second charge. You can't violate both independently. The second one requires a sign because otherwise the rule is that they're allowed to film certainly in certain areas, and we'll get to that in a moment. But they both ultimately rely on the same conduct and should merge. Now, additionally, Mr. Cordova can't be charged in the first charge because of the rule of specificity. The specific governs the general. Here, what we have is that to have violated the second count requires that there have been a sign or a regulation, and it is more specific. It says a security regulation. And that means that this 102.74.420 governs issues of recording and signs related to recording on public property. And the violation of a sign on recording is subject to this and not the other one. So I submit to the court that these two merge, and really it makes this second count the operative count. And ultimately then the question becomes twofold. Was this a security regulation that prohibited Mr. Cordova's recording? And we already heard testimony that first area was a foyer. In fact,
well, let's talk about this. So count 2 would not rely on signage because the CFR says, except by permission of the tenant, you can't film in certain areas, and that's not dependent on signage. It's freestanding, it's self-executing. It seems. Count 1 then does depend on signage. So I'm not yet agreeing that one is consumed within the other.
Okay, and let me reorder that argument, and I think you'll see where I'm headed. Count 2 says that persons may enter and take photography. Doesn't prohibit it. It says they may, except where security regulations prohibit it, they may enter into spaces occupied by tenant agencies. But I would say that that and is exclusive. So it's spaces occupied by tenants for non-commercial purposes. That's one scenario in which someone can enter into and film. A second is spaces occupied by tenant agencies for commercial purposes with written permission of an authorized official. And an additional option is building entrances, lobbies, foyers, corridors, and auditoriums. Those are 3 separate bases on which people can film. It's not all 3. It doesn't have to be all 3. It can be any one of those 3.
They're disjunctive.
Yes.
Yes.
So then the question is, if he was solely within a foyer and lobby, then there must be a security regulation. Okay? So what we already heard testimony on is that that area he was in was a foyer. So then the secondary question is, when he enters through those doors, what is the nature of that space? And if you turn to Exhibit 12, this would be Officer Ramos' statement. Officer Ramos repeatedly refers to this space as a lobby.
Right, but he doesn't get to define the law for me. His statements are not binding for determining as a matter of law where somebody is at a given moment.
Sure, but for matters of perception of what this space is and what would be reasonable for an individual subject to criminal offense to understand a space to be, Mr. Ramos repeatedly, at least 5 or 6 times in this report, refers to it as the lobby, the place that he enters into. If we told him, Mr. Cordova, if he entered into the lobby, he would be subject to arrest.
Have you been to this place?
I have not.
Okay, but you saw the video?
I have seen the video.
Is there any more possible interior space than what your client entered?
I do not know, and there's no evidence to say that there is or is not.
Well, from the evidence from the video, is there any more possible interior space than what he entered?
We've seen other interior space in the video.
You mean the glassed areas?
Well, no, there's the glassed areas. There are certainly doors. I don't know if there are spaces that people enter into to have private conversations, but throughout all of the discussions,
okay, so let me ask this. Did you see anybody doing any kind of transactions in what we've heard as the foyer or vestibule?
Not that I'm aware of.
Did you see people possibly doing transactions through those glass doors?
Possibly.
Okay, so the regulation says space occupied by a tenant agency is where you can't go without their permission. So I would, at least for the moment, unless convinced otherwise, believe that that initial space where most of the filming occurred was not a space occupied by that tenant. It was a common area for people to be. Going beyond those doors would be space occupied by a tenant agency, because clearly there were transactions going on. And if you actually look at Exhibit 8, first page, do you see the kiosk that says customer check-in?
Yes, Your Honor.
Do you see a screen evident in the video?
Sure.
Okay, so if a person had entered person identifiable information like a social security number and address, other information on that screen, a person videoing from right there could enhance that video and collect information off that screen. That, I believe, is a 201 to a scientific certainty that that could happen. So what do I do with that? I mean, standing in the lobby, you're fine. Having full access to people's information is a step too far. That's what I think is what's going on, and I know you know that too.
So, again, whether they do work inside of a lobby is not the point. The point is whether this would be properly understood as a lobby. And one of the arresting officers did understand it to be a lobby.
Are you in a lobby right now?
I am not in the lobby right now.
Is there a lobby behind you about 20 feet? Probably. We would call that a lobby?
I would define that as a hallway.
Hallway?
Or a corridor.
A corridor is good. But there's no business going on out there, and we don't conduct official business in that hallway. We do here.
And I didn't see any individuals of the Social Security Administration walking around the seating area conducting business either. Again, this was understood as a waiting room. As I provided to you in my motion to dismiss, a public waiting room is one definition of a lobby. One of the officers referred to it as a lobby. And again, they have to prove beyond a reasonable doubt this was not a lobby, right? And I think that there is a reasonable doubt as to the proper classification. And if this was a lobby, whether they were conducting business there is actually irrelevant under this statute. Once it becomes a lobby, then it is subject to this, except if there is a security regulation.
I'm equating conducting business with tenant occupancy.
I understand. What I'm saying is that he has the right to film in a building entrance, lobby, foyer, corridor, or auditorium for news purposes, except where there is a security regulation. A and B cannot be complied with together. One is non-commercial, one is commercial. So you can't be there for both non-commercial and commercial.
The initial clause of that CFR limits subsection C. You agree with that?
I agree.
Okay, so in the absence of any of those things, C applies. If there are those things, C may not apply. You agree that that's the way the statute reads.
And when you're saying all those things, you mean a security regulation, rule, or order, right?
Correct.
Okay, yes. Okay. So the first question for the court is the determination of the status of this room. If it is a lobby, then the only regulation can be a security regulation, rule, order, or directive.
Well,
if it's not, then it's a different story.
Do you believe that C was intended to collect similar locations, using different words to describe a similar location?
No, because an auditorium is not a foyer.
Yeah, and you know what? You just pointed out the only difference between those five.
And I would argue a corridor and a foyer are not the same either. I would say that they are all separate. An entrance is the outside when you enter into. Foyer is like outside of the security gate. Once you enter in, you're in the lobby where people do go up to the clerk of the court and potentially conduct business.
No. Downstairs, at least in this building, you have to go through a set of doors and then you're into the clerk of the court. But you enter from the lobby.
So I would define the area between the outside front doors and the security as the foyer. And then the area between the security and, you know.
So what you're saying is that what the government believes is the distinct space has sections in it under your interpretation. So 10 feet in, maybe you're still in something that would equate to an entrance, lobby, foyer, corridor. As you get closer to people actually doing transactions, then you are not. Is that what you're saying? Or are you saying the entire interior beyond those glass doors where your client was arrested is one of those things, a building entrance, lobby, foyer, or corridor? I got to know exactly what you're saying.
I would say the entrance in, the waiting room, and the areas where there are materials, public materials, that is a public lobby space. Social Security Office chooses to conduct their business in partially out in the open. And again, if we're concerned about privacy, then they shouldn't be doing this in a public space where someone can stand and listen and write.
But you didn't answer my question. Are you sectioning up with beyond those glass doors, calling a certain distance part of what's in subsection C, and then beyond that, what's not in subsection C? Are you claiming beyond those glass doors, the whole thing is subsection C?
I would submit that the first entrance into the area where there are public materials, the area where there's a waiting room, there's clearly conduct that would be tolerated in this area that wouldn't be tolerated along the walls where someone's conducting business. Looking over someone's shoulder while they're looking through pamphlets, standing next to someone in the waiting room or sitting next to someone, that might be tolerated, but at the same time walking up while they're at that window wouldn't be. And there is a distinction between those two conditions of that property.
But I got to know what you're arguing.
Sure.
Do you believe that there were spaces in that large room your client could not photograph under the law?
I would assert the whole thing is a lobby, to tell you the truth. You know, the Social Security Office, they can choose to conduct business in a lobby as they did. They could choose to have more private office space, which they didn't. But that was their choice. If the Social Security office is negligent with people's privacy, that's their choice. But that space was a lobby.
But you don't disagree there's time, place, and manner restrictions on free speech?
I don't disagree, and that's what this is. And I'm saying, talking about this particular regulation, if that space was a lobby, and at the very least, there is a question as to whether that space was a lobby, and there is evidence that one of the arresting officers interpreted that space as a lobby. So it's not beyond a reasonable doubt that that space was not a lobby. If that's the case, if that is the status of that space, then the only regulations are security-based and not privacy-based. Maybe the law should be better, but that's not what the law is. And when we're going to subject citizens to criminal sanction, we have to be specific. And while I personally would believe that if there should be a privacy exception here, that's not stated. And we should know what we're subject to. And here it says a security regulation.
So are you moving only on the video and not on the signage count?
I move on both because if you agree with me on the latter, then the former, on charge 2, then charge 1 falls within charge 2 because that is a more general prohibition to the specific of charge 2, which is security regulation. It narrows the scope on which regulations can be, and that's for security purposes. So if the only way he could violate this was by violating security regulation, then the other one folds. The charge.
Well, I think you can violate 74-420 without violating 74-385, and I think the opposite is true also. That's why I don't think there's lesser included.
I think it depends on the circumstance here.
Sure, of course, but I
think it would. If you were to agree that it was a lobby, then the way that he would necessarily have violated this was because there was a security regulation. And charge 1 is the only way he violates it is if there is a regulation, essentially, opposed to regulating his conduct. So if it's a lobby, then the only way you can violate charge 2 is it's a specific regulation and a security regulation. And the only way you can violate charge 1 is if it was a generalized. And I believe that the general yields to the specific here. So if it were the case that this was a lobby and this was not a proper security regulation, then both charges would need to be dismissed.
Okay. Any further?
No, Your Honor.
Anything? Do you want to offer any argument?
I think first, just to respond to this lesser included argument, which I think Your Honor already did to some degree. The argument assumes that the GSA regulation somehow preempts agencies from having their own signs and policies or anything else. I mean, whether or not there's a GSA regulation on photography wouldn't affect whether the Social Security Administration, for SSA policy or any other reasons, can have official signs. And like Your Honor indicated or suggested, there's not, one doesn't necessarily preclude the other. It's clear the agency occupies that space, controls the space, moves things. And so to say that it's not space occupied by an agency, or that paragraph C somehow subsumes the first 2 paragraphs for any lobby, and so there's always a reconsideration as you get further into agency space, even if the last area was prohibited, that this area could again be a lobby that again allows it, just seems a parsimonious reading of that statute that doesn't really work out. So that's the only thing I would really add, I think.
Okay.
I'm going to call Mr. Cordova.
Very good.
Good morning, Mr. Cordova.
Good morning.
Can you state your name for the record?
Christopher Cordova.
And can you tell me your occupation?
I am an independent citizen journalist.
Okay. And in what methods in which do you conduct your journalism?
I record anywhere that is publicly accessible.
Okay. And how do you publish your journalism?
I have several platforms. YouTube's my main one.
Okay. Tell me what brought you to the Social Security office that day?
We were doing a story on the Social Security office.
Okay. And in preparation for going out there, did you review any regulations?
Yes, I did review the CFR in question.
Okay. And what was your understanding of what was permitted?
Objection. Relevance.
Well, he's, okay, go ahead, explain.
State of mind.
Yeah, he's not asking him to interpret it as a matter of fact to overrule.
Sorry, so I lost train of mind. Can you repeat that?
Sure. What do you understand that regulation to permit?
It permits for news purposes audio and video recording in public accessible areas, including the foyer, the lobby, hallways, corridors, stuff like that. And I believe that that area that I walked into was a lobby.
Okay. We've heard testimony earlier today that posters were pointed out to you, correct?
Correct.
Did anyone tell you the nature of how those signs were official?
No.
Okay. Did they explain why you weren't allowed to record under those signs?
No.
Okay. Did you see any security lines in this office?
No.
Okay. And did you see any security being done in this office aside from several security guards?
No.
Okay. And do you recall if those signs prohibited conduct related to security?
No, I do not.
Okay. Do you recall being told that the reason you weren't allowed to record was for privacy reasons?
Yes.
Okay. Did you ever record anyone's private information?
No.
Was your intent to go and record people's private information?
Absolutely not.
Okay. What did you intend to record?
I intended to record just the public area. I wanted to get some pamphlets. I wanted to just kind of get some B-roll footage of the Social Security office, what it looks like, just the public area, but absolutely wasn't trying to record someone's personal information.
Okay. Were you ever going to walk up to one of those vestibules or the windows where people are conducting business?
No.
Okay. And were you expecting to be there for 3 hours?
No.
How long did you think you'd be there for?
Maybe 10 minutes, 20 minutes max, probably not, probably like 10 to 20 minutes.
Okay. So the area you were standing in, what did you understand that area to be?
A foyer.
Okay. And what did you understand the area through those next doors to be?
A lobby.
Okay. No further questions, Your Honor.
Thank you. Cross-examination.
You said on direct that you were there to make you said on direct that no one explained why you cannot record in there. Did I hear you say that?
Correct.
So the whole time you were there, the 3.5 hours, no one explained to you why you cannot record in the Social Security Administration space.
I can't recall them explaining why.
You recorded a video of all your interactions with the officers that day, didn't you?
I did.
I'm going to play just a couple clips from that video.
That's all we want you to do, dude. Uphold the Constitution. Just uphold the Constitution. Uphold our rights. If you just uphold our rights, we'll leave.
Actually, I'm gonna play you a different one. That one, it's a longer clip. Stacey, if you can go to from Government Exhibit 1.
Policy enforcer here, guys.
Alright, how you doing? I am going to advise you once again, since you know your First Amendment auditors, you know GSA policy for federal property. If you'd like, you can go ahead and read it in a highlighted area. You cannot record because of special circumstances, regulations, which you were briefed outside before entering the facility because people's personal information. You were also briefed inside before you were attempting to enter the facility. One, as you did, you photographed, you cannot record. You also
Did you hear the officer on that video state that you can't record in there because of people's personal information?
I did.
Do you recall being told that the reason you weren't allowed to record was for privacy reasons?
Yes.
Mr. Cordova, you also told your viewers that day that you were there to create a court case. That was your purpose, right?
That's incorrect.
You did not tell your viewers that you're there to create a court case?
I don't know if I said that I was there to create a court case. That was not my intent. My intention was to do my story. If subsequently I get arrested, that would create a court case, but I am there to exercise my First Amendment right. That is true.
I'm going to play you a clip from Government Exhibit 4.
I go. You want to say to people since you took the ride?
Thanks for coming here, guys, and supporting us as a community. And I told you guys that we're going to go in here and we're going to do this because I'm here for you guys, man. This is our channel as a community. And when we come together and unite, this is how we affect change, guys. This is going to be something that's going to be a staple in being able to come in here, guys. We're trying to create case law.
I go.
So what is the statement that you're using to impeach, please?
So at the very end of that video, you said we're here trying to create case law. Did I hear that right?
After I was arrested, then yes, I would like to create case law. But my intent was not to specifically go in there to be arrested.
Your intent before you were arrested, though, was to create a paradigm shift, right? A paradigm shift in First Amendment law.
No, my intention was to do a story on the Social Security office.
Did you tell your viewers before you ever went in that day that you were there to create a paradigm shift?
I never used the word paradigm shift.
I want to, Stacey, if you can play, Ms. Levitt, if you can play.
In tribal times, it was advantageous to just submit to the alpha, right? Because if you go against the alpha, then you're dead, and then your offspring's dead, right? So, and today, our brains are still hardwired that way, to submit to the alpha, submit to the officer. So they're used to just giving orders like that and getting in your face aggressively, and people just accepting it, and they're not used to people not accepting it. And that's what we're here to do, guys. We're here to have a paradigm shift here. We're not accepting this.
So at the end of the video, you said, we're here to have a paradigm shift. Did I hear that right?
You did hear that.
Nothing further, Your Honor.
The paradigm shift that he's talking about is not a paradigm shift in First Amendment law. It's a paradigm shift in the way people think. You see, like Craig Fansler thinks that I should go to jail for 20 days for taking pictures in a lobby because people's personal private information is in there. And I believe that they should stop blame shifting and maybe design the building a little bit better or set up the building a little bit better when they decided to lease this space to where you don't have to violate people's rights in order to protect their privacy. And it's not that I don't have the balls to say that on the stand, I just didn't think of it, guys. But that would have been a mic drop moment. All right, guys, let's finish up this video, and thank you for watching this thing all the way through.
Briefly, we just heard you say the term paradigm shift. Mm-hmm. You heard that was an hour into your video, right?
Yeah.
Did your intentions change from before you went there to an hour in?
Yes.
Okay. No further questions, Your Honor.
Okay. Any requests? Okay, you may step down.
Okay.
Thank you so much. Any other evidence?
No, Your Honor.
This is not a complicated case. It's not complicated regulations. It's about official signs. It's about lawful directions. It's about security rules, orders, and directives. And it's about space occupied by an agency. So 2 counts. Count 1's noncompliance with official signs or lawful directions. The government must prove first either that there were official signs posted, or second that federal authorized individuals gave lawful directions, and second that the defendant didn't comply. The official signs, Commander Wiles said that they were official signs. They weren't developed by this field office. They were from Social Security Administration. You saw the text of them that clearly prohibited this conduct. You saw multiple officers, multiple federal authorized individuals, either FPS employees, Federal Protective Service employees, or those contractors for the Federal Protective Service, which Commander Wiles testified were also federal authorized individuals, give those lawful directions. And Mr. Cordova didn't comply. Here I go, guys.
We're going to arrest you, man. Ready? There you go, man. You're now under arrest. You're now under arrest. They're arrested.
Brings us to count 2, unlawful photography. The elements are that first, the government must show that the defendant took photographs, that either security regulations, rules, orders, or directives prohibited photography, that the photographs were of space occupied by an agency. It doesn't have to be standing in the space, it just has to be of space occupied by an agency, that there were non-commercial purposes, and that the defendant didn't have permission. He took photographs. He posted photographs in the form of a 3.5-hour YouTube clip. We saw many videos from that, many clips from that video. So he took photographs. Security regulations, rules, orders, or directives prohibited photography. There is a rule The rule very clearly has a warning sign and with exclamation points and triangles in top. Photography and videography prohibited. The defense counsel made a lot of the argument that it's not a factual, but whether the reports knew it was a security sign or not. Ultimately, the people who testified were Federal Protective Service employees, and they didn't know at the time. Whether that's in the reports doesn't really matter. What Commander Wiles testified today is it was a security sign, and he followed up and found that out. There were orders.
This is the time and place to argue it. I'm telling you right now that I am not going to allow you to film beyond this door. I'm already allowing you to film beyond that door.
And there were directives. Mr. Cordova calls it a directive.
They asked you to leave, you did not wish to leave.
So you're asking me to leave?
I did.
Politely? Okay. I'm asking you to give me $5. Can you give me $5? Because
Okay.
I have this policy. I have my own policy that everyone I talk to has to give me $5 that gives me unlawful directives. So.
An unlawful directive. And the space was occupied by the agency. You see the kiosk. You see the customers meeting with agency officials. You see agency chairs, agency signs, agency pamphlets. It was clearly space occupied by an agency.
Of course, we understand that even a lobby is a space controlled by the agency. So Craig Fansler lists off a whole bunch of items as though that proves that it's a space occupied by the agency. But the things he listed, agency chairs, agency signs, agency pamphlets, are all things in which you would find in a lobby.
So the government submits it. It's proven its case beyond a reasonable doubt on both counts, and the court should find the defendant, Mr. Cordova, guilty of both counts.
So I'm going to do something rare here and agree with the prosecution regarding the interpretation of this rule. There are three purposes under which this second charge, 41 CFR 10274.420, applies. There are the commercial purposes of an individual, there are the non-commercial purposes of the individual, and there are the news purposes of an individual. Okay? And there is not the sense of these spaces are occupied and these spaces aren't occupied.
You know, wait, hold on. I think I may be misreading that. So it is photographing for a commercial purpose or photographing for a non-commercial purpose. It's not whether the tenant is using it for a commercial purpose or non-commercial.
That's my reading.
I would agree with that reading, Your Honor. And I think he
drafted poorly.
That's all, folks.
The space, it ought to say it may take photographs for commercial purposes if, for non-commercial purposes if, and of building entrances. But now I see what you're saying and I agree with you. Okay, go ahead.
Okay. And that means that that third section, for news purposes, is distinct and different. And the idea that the distinction between A and B and C is whether the tenant agency is occupying the area or not, that's not a correct reading of this statute. Auditoriums, are those just free-floating spaces that nobody owns? Of course they're occupied by the tenant. All of these spaces are occupied by the tenant, including a lobby. A lobby is not a free-floating space that nobody owns and nobody manages and nobody has rights over and nobody locks the doors.
And you can't spend the night there either, probably.
I would presume that you can't spend the night. And in fact, they even talk about that being a foyer and that they lock the front doors outside. I assume that no one can sleep in that space, in that vestibule. So the distinction is not this was a tenant-occupied space, so therefore 3 doesn't apply. The question instead is, was this an entrance, lobby, foyer, corridor, or auditorium? And those are all distinct and different spaces. Certainly a corridor is something to be like a hallway, which is not a building entrance. And as I've made this argument multiple times, a lobby is different than a foyer. A foyer is where you walk into. When you first walk in, maybe that's where you take your coat off. A lobby is where you wait. A lobby is a public space where you wait to be served. And at the very least, both for the purposes of whether the people have proved beyond a reasonable doubt, but also for the purposes of ambiguity under the First Amendment. And the First Amendment is absolutely called into question here because this was photography. The 10th Circuit recently in Yahia observed and recognized a First Amendment right to film public operations. Now, obviously, that makes it subject to further, forum, non-forum. And if you'd like, I can give you a site for Yahia v. Irizarry. I was on that case.
I know Mr. Irizarry and Mr. Brandt very well.
Yep.
So let me ask you this.
Sure.
So from a textual standpoint, A, B, and C are distinct.
Yes.
And C attempts to distinguish a space from that identified in A and B. You agree with that?
Yes.
So what is the difference we have to ask, right? And you're saying it's so vague it doesn't give somebody notice? Is that what you're arguing?
I believe that there is an element to that, yes. If the fact that one of the police officers himself described this space as a lobby and another doesn't, that goes to showing this ambiguity. And it would be reasonable.
One says foyer?
One refers to as a waiting room.
Okay.
If you review the two, in fact, if you were to review all of those, I know they weren't admitted, but in Exhibit 12, every single person, the other people refer to it as a waiting space or a waiting room.
The space he was in first for most of the time?
No, the later space.
Okay.
It's never referred to as the offices. It's referred to as a waiting space, as a lobby. But whether it was...
Wait, who refers to it as a lobby? And where do they do that?
Officer Ramos, I believe.
The space beyond the second set of glass doors.
Yes, yes. I'll turn your attention to Exhibit 12. And upon arrival, we entered through the foyer and into the lobby. Later, he advises the individuals were advised by the on-duty PSO that they were not allowed to film in the lobby of the SSA.
But are you aware of the word lobby being used in any of those videos? And I assume
I'm not aware of that.
Are you aware of the word lobby being used in any of those videos?
I am aware of a clip I did not play where Commander Wiles actually explains why he does not consider it a lobby.
And I'm not familiar with that
Very
clip,
good.
but regardless,
No, not regardless.
Sure.
If he had called it a lobby to Mr. Cordova's face,
yeah,
that next space,
sure,
that could be a problem for the government.
Inside the lobby here? Does
This
it say
is not a
we can
lobby.
film inside the? Oh, this is not a lobby.
A foyer. This is not a lobby.
Oh, what is this then?
This is a waiting area. This is a waiting area. This is a waiting area where there's PII
It's a lobby.
being
It's
divulged.
a lobby. It says clear as day in the lobby. We can film.
If one of the officers had called it a lobby, that could be a problem for the government, says Magistrate Hegarty. Well, good thing he's safe there because he, in fact, did not call it a lobby. He called it a waiting area. Just as Magistrate Judge Hegarty said, people were in chairs waiting their turn. And where do you guys think people wait their turn? Well, I could throw a wild guess out there and say a waiting area. And just as I said in the beginning of this video, and as my attorney said, synonyms for a waiting area include lobby. Would you look at that? Isn't that amazing? So, do you see the deception going on here? Do you guys see the lengths that they'll go through to not be held accountable? That could be a big problem for the government, he said. But he didn't say lobby, he said waiting area. So they are going to stand by that I should be locked in a cage for 15 days, actually 16 days, because it's not a lobby, it's a waiting area. They want to lock me in a cage over semantics. This is just absolutely disgusting, guys. I am completely appalled.
Of course, that would...
Because the word lobby is explicitly used in a regulation as a place you can photograph.
And I understand. Of course, that would be better for me. Of course. I would say that would categorically make it so that this was a lobby. What I'm saying is instead, it is not categorically not a lobby. And they have a burden of proof here, that it is beyond a reasonable doubt that that was not a lobby. And here is one of these two officers, arresting officers, calling it a lobby. But also for the purpose of the First Amendment, there's the question of vagueness. That we should not be subject to criminal sanction for otherwise protected activity unless it is definite. And if one of the arresting officers calls this a lobby, I don't know how that's not vague.
You're arguing that where your client ultimately was a 74.420C space.
Correct.
And if it's not, then the statute is vague. That's what you're saying.
Correct.
All right.
My primary is that he was protected by this. The secondary would be they haven't proven, actually, there's a second in between those two, that they haven't proven beyond a reasonable doubt that this was a lobby, and I suppose that's kind of a subsection of that first argument. And then the third would be that if it is determined that this was not a lobby, that this is not within that space in C, then it's at least vague,
to the degree that it does not provide.
But does proving beyond a reasonable doubt analysis even apply to a court's legal decision about what a space is and whether a statute is constitutional or not? Because proof of a reasonable doubt is what factually occurred.
Sure, and I believe that one of the elements here must be that he was not performing news services or news activity for news purposes in a building entrance, lobby, foyer, corridor, or auditorium. That is an element. And I believe that that element needs to be proven beyond a reasonable doubt, too. That they must prove beyond a reasonable doubt that, all three, A, B, and C. Now, we're not contesting A and B. He did not have permission. So it really relies on C, but they have to prove C beyond a reasonable doubt. And to prove that, they must prove that he was not performing news services or that he was performing news services but was not doing so in a building entrance, lobby, foyer, corridor, or auditorium. And that proof, that element must be met beyond a reasonable doubt. I believe at this point that the United States has not proven beyond a reasonable doubt that this was not a lobby space. They've introduced testimony of one individual who does not work there, who does not frequent that space, but we do have evidence where there is some understanding of this space by these federal officials that it was a lobby. Turning then, these regulations, these signs that they've posted, they're not security regulations. You have the job of making that determination, but we've heard over and over, this is for privacy purposes. Those are maybe important policy considerations, but they're not security purposes.
How are you viewing the word security in this context?
I believe that that is akin to you can't record security officers, the ways in which we secure the building. If we were to say security means securing people's personal information, I don't know. I worry that we could say we're securing people's ability to eat lunch. And so no filming in public courtyards. We are securing, it would stress the word security beyond anything if it goes beyond what is actually securing the building. And if that were to be...
Well, have you been to the National Archives?
Not in many years.
Have you seen the U.S. Constitution? Or the
No, I've never seen that while I was
walk
there.
in and see the original, and it's behind a very thick piece of glass.
Sure.
You can stand there and look at it.
Yeah.
Would you call that piece of glass a security device for that document?
I think that's arguably, yes, a security device.
For the purpose of securing a piece of paper?
Correct.
So security can refer to both the security of a person and security of property.
Sure.
You agree?
Yes.
So anything in there that's intended to secure both information, paper, property, and persons could be reasonably viewed as security.
I would agree, but again, we're talking about now protecting, not securing. And those are two different terms. Protecting people's privacy rights is different than securing, security of the Constitution from theft.
No, I'm not so sure. So you see that kiosk that had the two sides where somebody standing next to it couldn't see what the person is doing?
Yes.
That's a security device for making sure someone over here can't see what somebody's entering on a computer. Would you agree?
No. I would submit that that's a privacy device. They weren't trying to secure people from harm, and they weren't trying to secure documents from theft.
Well, theft can be both physically taking and actually, when identity theft occurs, no one's physically taking anything.
Sure.
They are taking information and using it in an improper way. That's still theft, correct?
Yes, I think we're torturing this definition of security beyond.
This is apples to oranges because if I was hacking a database, stealing documents, deceiving someone into obtaining their social security number, buying numbers on the dark web, or impersonating someone to get their social security number, then that would fall under identity theft statutes, fraud statutes, computer crime laws, wire fraud, and identity fraud. But simply taking pictures in a public space in which I have the right to do is not by itself illegal. Again, Judge Hegarty, aka the government, is shifting the blame onto me instead of taking accountability for forcing you to conduct business in a public lobby. And yes, I still stand by, this is a lobby.
I worry if all of privacy is encompassed within security, then this is a much broader statement. I think personally that...
We're having some fun here.
Yeah.
Do you have any problem, would your client have any problem with a U.S. government drone flying over his property that has one of those cameras so good you can see from outer space and videoing everything that he's doing, including through his windows into his house? Do you have any problem with that?
Yes, but that's not a concern of security. That's a concern of privacy under the Fourth Amendment.
Right.
I'm distinguishing. I think that there's a distinction between privacy and security.
Take that same camera and it's looking sideways into somebody's personal information. Any difference?
I'm not saying that there shouldn't be a regulation for privacy. I'm saying that this one doesn't. Plain language is clear here, and it says security. They very well could have written security or privacy.
74.385.
Yes. I'm not speaking to what would be good policy. I'm speaking to what's written. And what's written does not contemplate or discuss privacy concerns. It discusses security. And I think largely what is intended here would be the security line. You know, security cameras, making sure that people aren't breaking into facilities and that we're securing these buildings. This is not what should be, but what is, Your Honor. And what is does not say personal information here. Nobody ever said the word security until they read over the regulations and got into court. There was no discussion. These are for people's personal information, their confidential information. This is for security purposes. So, again, I've seen no proof other than some, I would argue, self-serving testimony that this was a security regulation. We have not seen where this comes from. We have not seen the folders. We have not seen testimony from someone that drafted it, that an administrator at this building that said this is what this is for. We've heard some testimony that this is held somewhere on some database in a security folder. But more to the point, these signs don't specify the purpose. They don't narrow in on security purposes. They just have a general broad prohibition. I will tell you, I did a case law research for security regulation, and essentially every single result that popped up was Homeland Security regulation or Social Security regulation.
So you don't think my research is going to show anything that interprets this particular regulation?
I mean, I doubt it. I doubt it, and I have not seen any interpretation by the Social Security Administration as to what this means. Certainly no evidence has been produced as to how the Social Security Administration interprets the term security regulation. And it would seem problematic to me to interpret it differently at each case whenever they're pursuing a conviction. I think it would need to be ahead of time. But I don't believe that there is such a regulation or interpretation out there. Turning to those signs are not clear that they prohibit his conduct. They say in the offices. I don't believe that this was an office space. This was a large space, but the office would be behind those glass doors. They would be in those hallways. They would be in private spaces. The first one, it says while in the office with these pictures of these cameras. The second one says federal law and SSA policy prohibits taking pictures inside SSA offices. Both of them refer to offices. And offices, plural. Not the office. Not the Social Security office, but offices, right?
Look at Exhibit 3.
Mm-hmm. Okay.
See what the top sign says?
I do. I would say that office hours is a slightly different term of art than office. We're picking at threads here. I will agree.
It's not a thread.
No. What I'm saying is distinguishing different spaces is different. Probably not going to have foyer hours. These are the hours you're allowed in the foyer. But I think it's pretty indisputable that this space that they were in for the 3 hours was a foyer. But I would say that that term refers to the whole space, but offices is a distinct word, or at least is reasonably understood to be a distinct phrase of you don't get to videotape when you're in someone's office, when you're at that space. That's different than when you're in a lobby. And again, ultimately, I fall back on my previous argument that the specific overrules the general. They can issue lots of rules and posters that aren't spoken to elsewhere. But as it relates to photography, 420 is clear. It has to be a security regulation. These, as we've heard, refer to confidentiality and personal information, not security mechanisms. And the last issue I would point out, Your Honor, is I don't know how to tease this out. Believe me, I've thought about it. I don't know what makes a sign official and not. I haven't heard testimony as to who placed this, if this was just a janitor who threw this up, if someone with a printer that didn't want to be photographed threw this up, or if this was an officially, enacted, adopted poster by the person that controls this office. Certainly that person was not here to testify today as to how this poster came to be posted.
Yeah, you're not going to die on that hill, though, probably.
I'm not going to die on that hill, but and the truth is I really don't know how
The people would prove that other than bringing someone in to testify, yes, I did adopt that. But it doesn't say signs of a prohibitory, regulatory, or directory nature, but official signs. And at least I would say the evidence does not support a finding beyond a reasonable doubt that these are official signs. The United States could have brought someone in to speak to how these signs came to be posted. They didn't. That was their choice. But they have an obligation to prove each element beyond a reasonable doubt, and one of those elements is that these signs were indeed official. And I have seen no evidence. Certainly Mr. Wiles does not have that personal knowledge or information. I have nothing further, Your Honor.
Thank you.
Thank you.
Any rebuttal?
I know that we talked about the signs not being the hill to die on. Commander Wiles did talk about them coming from the Central Social Security Administration. And the other thing, I don't think Your Honor even needs that testimony. You have the photos that show the official seal on the bottom, the GSA seal and the SSA seal. It says federal law and SSS policy does this. I mean, the fact that they're official.
Produced at U.S. taxpayer expense, it actually gives a publication number. It gives an ICN number. Again, he said he's not going to die on that hill.
That's right, yeah.
When did my attorney say that he wasn't going to die on that hill? The judge said, "You're not going to die on that hill, are you?" They're putting words in my attorney's mouth. In fact, my attorney is adamant about how these signs are not official, and he's going to explain that in further detail coming up.
Yeah, I don't have anything beyond that to add that we haven't already.
Okay. Your Honor, briefly.
You may.
Those numbers, you should Google them.
Okay.
I haven't found anything.
The ICN?
Yeah.
Well, not everything's on the internet.
I would hope that the government regulations are, though.
I'm not even sure what ICN stands for. International something number, but whatever. Okay, so are we considering the case submitted? Okay, we'll be in recess, take the matter under advisement.
Thank you, Your Honor.
Thank you all for your presentation today.
All right.
All right, if you've made it this far, then you're definitely going to want to watch part 2. This ended up being a 3-part series. I wanted to get it into one video, but it's way too much information. Part 2 is the sentencing hearing, and it's a whole different level. My attorney comes in a lot more fired up, the arguments hit harder, and that's also when I personally addressed the judge before being sentenced to 15 days in jail, which I ended up serving 16. Part 3 is the security footage from my stay in jail, and that's a whole documentary on its own. So if part 1 kept your attention, part 2 is going to hit even harder, I promise. So make sure you're there for it. Thanks for watching, guys.
You don't put your hands on free members of the public unless I commit a crime, and I'm not committing crimes. I already told you cannot come in. And I already told you, bud. I already told you.